let me see. Okay, so yeah, so that's Jack. That's our firm's mascot. That's me. So there's my contact information. If anybody needs to reach me, you can reach me by email or phone. Happy to talk. Any questions that might come up after the meeting. So our firm is a general practice firm. We do all kinds of things, you know, from A to Z. I'm like I said, I'm in the IP group, but we do help businesses. Basically, anything that a business would need, we can help them with those needs. Okay, so I guess first, like I said in kind of my intro, the intellectual property is a kind of an umbrella term that includes patents, includes trademarks, includes copyright, and includes trade secret. Those are generally the four categories of intellectual property. And most inventors, most companies, and frankly, most individuals, they're going to run across trademarks more than anything else, than patent or even copyright. And so I wanted to start off with with trademarks, since that is probably where a lot of the questions are going to come from. Well, a little typo there at the beginning, but a trademark can be anything. It can be a word, it can be a phrase, it can be a symbol, it can be a logo. And what it is, it functions as an indicator of source. It's something that you point to it and you know, oh, they make soda, or oh, they make cars, or oh, they make, you know, shirts, whatever it is. And so I've provided a few at the bottom of the slide. You know, you immediately know what these companies make based solely on those trademarks. And so that's the purpose of that trademark is, you know, you can look at it or you can hear it and you know exactly what they make, you know exactly what it tastes like, or you know exactly what, you know, the way it fits. And so it works as a stand-in for all those. And so instead of saying, you know, this soda tastes like this, that, and the other thing, you just say, oh, it's a Coca-Cola, versus, oh, this is a Mountain Dew. So you immediately know what those characteristics of that product or that service are based solely on that trademark or that service mark. So, you know, service mark versus trademark. Service mark is for services. You know, UPS, FedEx, those are services. There's not a tangible good necessarily associated with those. Trademark there is a tangible good. Trademark is kind of a more general term. You can use them for both goods and services. But if you want to get technical, service mark, trademark. So go ahead.
I had a question about the trademark. So Coca-Cola, so do they have the logo trademarked and the name? And the reason I'm asking is because like when I go to Cracker Barrel, they sell a Coca-Cola brownie or Coca-Cola cake or something. So did they get permission to say they got a Coca-Cola cake, or Coca-Cola doesn't have a mark on the name, just the logo?
So who has this?
Cracker Barrel. Cracker Barrel. Yeah, they have like a Coca-Cola cake for dessert. So I'm just wondering, like, and they may have gotten permission. I don't know. Maybe they're using Coca-Cola products in the cake. But I guess I was just wondering about like how people able to use like the Coca-Cola name and the Crystal name and in other things.
Well, let me ask you a question. Does that cake, does it have Coca-Cola in it?
I don't know. It just is called Coca-Cola cake. I would assume. I don't know. It's called Coca-Cola cake. I'm assuming it might have Coke in it, but of course they don't list. They're not giving us all the ingredients in the cake, but you know, it's just a dessert that they have. So when you were talking about like it could be the word and the logo and you know the font. Mm-hmm. So I guess I was just wondering, and you may not know if Coca-Cola name.
Yeah. I don't know that specific instance. I know Coca-Cola is very defensive of their brands. So if the cake does have Coca-Cola in it. You can say this cake has Coca-Cola in it. Like you can truthfully say that.
Okay.
But if it doesn't, I think that they'd be in trouble there. But yeah. So in addition to trademarks and service marks, there's also kind of a lesser known, lesser used area of trademark law. It's called trade dress, and that's the look and feel, basically the way that a store might look. One example in Knoxville, for example, is Chewy's. You might have been into Chewy's, and they have a very distinct, like, they have all those things everywhere, statues and pictures and very bright colors. So the way that restaurant looks is completely different than the way, say, a Wendy's might look, right? And so you walk into Chewy's and you're like, man, I'm in a Chewy's, and you can tell that. And the same with Cracker Barrel, like they've got the fireplace and the checkers and the old timey stuff like that. The way that restaurant's kind of set up and the decorations, that's trade dress. The way that you've decorated the product or the service. And then I guess last is the trade name, and it's very similar to a trademark, but it's the trade name is actually the name of the business. And so like Coca-Cola, like the name of the business, I think it's Coca-Cola Bottling Company. And so that would be the trade name. But the trademark would be just Coca-Cola. Another example is, what is it? Is it Alphabet is the company name for Google, right? But the search engine itself, like the service that it provides, is called Google. But again, Alphabet is the parent company name, or is the company name. So that's the trade name. So they can be the same. The trade name can be the same as the trademark, but they don't have to be. One area that I see a lot, clients that aren't quite familiar with all this, they'll say, well, I searched the name with the state and it says that I'm clear. There's nobody else using this name. And a lot of times what that is they've searched the company business name, Acme Inc., right? There's no other company that has filed paperwork with the state to set up an entity called Acme Inc. And that's completely different. That search is completely different from the trademark. And so you might have an Acme Inc., but they're doing business as, Shora, right? And so if I start doing business as Shora, and Tanika might have a problem with that, right? Because I'm using her trademark. And so that's an issue that I see a lot when people say, it's fine. I've done the search. I've cleared it. And so you have to know that distinction, that there's a difference between the business name and the trademark that business is using for its goods and services.
So I have a question, if this is question time.
Yeah,
is this like an interactive thing?
Yes, it is.
So this makes me think. So our family business, B&B Lawn Services, right? So B&B stands for, their names are Baffin, Baffin. So it's Baffin Jr. and Baffin Sr. So that's where B&B came about, started 30 years ago. Well, our cousin actually, who is a graphic designer, designed the logo. So that's probably been about, it had to be in the 90s, maybe early, how old is Mark? Maybe late 80s. But anyway, he designed the logo where there was like the two B's were like back to back from each other. Well, even here in Knoxville, they have like B&B like hair, but the B&Bs are like back to back to each other.
Right.
There's another like B&B landscaping in Texas. So I guess I'm trying to understand. So could it have been, well, we could have trademarked B&B lawn care and landscaping and then trademark the image? And then,
yeah.
So that's one question. And then if we did that, how would that have affected maybe other businesses, even though it's not the same type of services provided?
Yeah, good question. So the answer to your first question is yes. You can have separate, and I might have a slide on this. Let's see. Give me 1 second. You can have a, nope, getting too far. Don't look at all that. That's for later.
I'm actually just looking at y'all right now. So don't worry, I didn't see nothing.
So yeah, you can have you can protect the name by itself without any kind of logo, and then you can also protect the logo as well. So Coca-Cola is great because they do branding really well. So you can see the bottle there. The script font that you see on Coca-Cola, they've got that particular font protected, the words Coca-Cola in that particular font protected. They've got the words Coca-Cola without any particular font protected. And then they've got, they've got the little swirly thing underneath, that's protected. So really any of that can be protected as a trademark.
Okay.
And so your second question is, if you had B&B registered for lawn care service, but then somebody else had it for hair care or for t-shirts or for whatever, well, that goes into what's called the likelihood of confusion test. And in the world of trademark, that's the big one. That's the big issue, is because we don't want to have confusion between these two sources of products, right? We don't want my customers to be confused by your customer, or be confused with your customers. And so it really only becomes an issue if the consumers are starting to be confused. But if I'm trying to buy lawn care service and I'm looking for B&B, that's not going to necessarily confuse somebody that might be looking for soda. Right?
Okay. Right.
And so you have to compare not only the trademark, B&B, but you also have to compare what it's being used for, the products and the services.
Okay.
And so it's basically, and a lot of times it's a two-factor test that you have to look at. For famous trademarks, it's a little bit different. So like Coca-Cola would be one. And these are like big name products, big name services. And like you couldn't go out and sell Coca-Cola lawn care. And the reason is because they are so big, it becomes an issue, what's called dilution. And so that issue is Coca-Cola selling lawn care services now? And so it's not quite, they're becoming confused, between two sources. It's lessening the strength of this trademark to represent sodas. And so that only applies to certain types of trademarks. But usually you got to have lawn care services versus lawn care services, or landscaping versus lawn care. It has to be something in the same realm at least.
So then, when you mentioned about the person who was like, well, I looked it up and there's nobody in Tennessee operating under B&B lawn care services, but there is somebody in Texas saying they're B&B lawn care services. Could that be a red flag?
Yeah, possibly. And it's the same question. If you are providing lawn care services in Knoxville, is somebody in Texas going to necessarily be confused by that?
You know what? Ironically, we have gotten maybe not a lot, a handful maybe of calls that they think that we're somewhere and we're not there, because I don't know what they're Googling, but I do see what you're saying though. I get it. It's not been a big deal. I was just asking.
Well, yeah. But that's the question we ask is, are consumers going to be confused? And if they are, like if you're seeing that, then yeah, I would, as a lawyer for you, I would write this Texas group and say, hey, you're causing my customers to be confused. They're calling you instead of calling me. And that's what trademarks are trying to protect against. But usually you have to have some sort of geographic overlap between where you're providing your services and where this other person is providing their services. So if like massage services, like you have to actually be there in the massage parlor, and landscaping service, you have to actually be there in the yard. Like usually that's fairly limited to where you're actually providing those services. The scope of your rights to protect that name are going to be limited to where you're providing those services. But I guess that might help go to the next, let's see. Okay. so this is kind of going to that question.
Mhm.
There are three levels of trademark protection. So if you don't file anything, like you just start selling products or you just start providing lawn care service and under B&B, you're going to have what is called common law trademark rights. And those are unregistered trademark rights, and you get them automatically just by using the name. Okay. And so that's this one on the far left-hand side. So this is an image of Hamilton County where I live. So if I'm providing legal services under Acme Legal and I haven't registered anything and I'm only providing them in Hamilton County, you know, maybe that's the extent of my legal protection for that name, right? And that's, again, if I don't do anything, I don't file anything, I just start selling my services. But then the next level up from that is the state trademark registration, and that's here in the middle. And that's where I have filed an application to register that name, Acme Legal, whatever it is, with the state of Tennessee. And so in that case, my trademark rights are protected throughout the state, even though I'm only here in Hamilton County. Okay.
Mhm.
And so that would give me potentially the ability to go to, say, Memphis or Nashville or to wherever else and say, hey, quit providing services, you know, under the name Acme, you know, legal services under the name Acme. I'm in Chattanooga and I've got this registration. And kind of the same idea going to the highest level of federal on the far right. You know, we're here in Tennessee providing lawn care or legal or whatever, but we've registered. And, you know, to your point, you know, somebody in Texas or California or wherever, you know, our rights now expand nationwide, even though we are only in
Mhm.
one area. And so technically it would still require you to have that geographic overlap. But what it does is if you do go to Texas or if you do go to California, you can make those people stop using that name because now there is that overlap. So basically the advantage of registration is it reserves that name until you get to that place. It holds your rights for you, and it'll give you the ability to say, hey, stop using my name. So that's the advantage of the registration process. So does that answer did that help at all? Is that
Yes.
okay?
Mhm.
Good. I'm gonna go back a little bit. I think I've gone through all of this. No, I didn't. So public face of the business, you know, it's how you're selling your product, Coca-Cola versus, you know, or Google versus Alphabet. You know, we you know, I saw Tanika, she was like, what? Alphabet? That's because you never see that. Yeah. But you do see Google. And so it's that public face of that company through its search service is called Google. And so a good trademark, you know, some what it does, some advantages. You know, one of the major advantages, and we'll talk about patents a little bit, but one of the major advantages of a trademark is it can last for forever. The protection that you get. So as long as you're using that trademark, you can keep it protected. I think Wells Fargo, I think its registrations are over 100 years old because it's been in business for so long. Yeah. And, you know, as you continue to use those trademarks and people learn more about you and they learn more about that brand, the value of the trademark increases. So trademarks are very, very good for businesses, and they're reasonably inexpensive compared to patents. So it's a lot of times it's one of the better options for new businesses. So there's a right and wrong way to use a trademark. So this is the correct way. I need a Kleenex tissue.
Oh, wow.
Yeah. Versus I need a Kleenex, where you're, you know, the danger is that you can start to refer to the entire category of products, so tissues, by the trademark. Okay.
Mhm.
So it might be a tissue that's not a Kleenex. It's not a Kleenex brand tissue. It's provided by whoever else, but you're calling it a Kleenex, right?
Mhm.
And so now it's like, well, this word Kleenex now is like a stand-in for the word tissue. Okay. And so
Mhm.
it becomes kind of a generic term. So like escalator, like that used to be a trademark. Aspirin used to be a trademark. And so now it's called genericide. They became so popular, so famous that people were using them in these incorrect ways that they lost their trademark rights.
Wow.
Hmm.
Yeah.
Was that on the business? Was that on aspirin, or was that because the people?
That
I mean,
is on both. Aspirin, you have an obligation, or trademark owners have a duty to prevent that from happening.
Mhm.
And you'll see some advertisement where they say these in an attempt to prevent this from happening, they will advertise. It says, "Hey, don't use our trademarks like this. Use them like that." And so that's what they're doing, is to try to claw that back, prevent that from happening. But again, usually this is an issue that only affects really big, really famous companies that the whole nation is going to be using, right?
mhm.
But it is an issue to be aware of. So I guess a couple other pointers. You want to use the trademarks in a prominent fashion. You want to point them out. You want use them in bold font. Use them in, you set them off from the text of everything else. So you want to make it clear that you're using this to brand, and so that's usually a good idea. So one of the big issues is in trademarks is you have companies that start using the name without doing any kind of searching on the front end. And that's fine until you build a whole business around it. And then, somebody else comes knocking and they say, "Hey, you've been using my trademark. You got to rebrand. Oh, and by the way, you got to pay me all this money." And so the absolute first thing that should be done is clear the trademark. And that's not just, has somebody registered as a business name at the state level, like we were talking about earlier. It's not just has somebody registered it at the federal level, because even what I said was common law use, so the unregistered use, that can still cause problems. And so a lot of times it's the common law, the unregistered users that I find in my searching for my clients that cause them to not adopt that trademark. So that should be a good first step for anybody thinking about branding something.
Now, let me ask this. So if, taking Harper's Naturals, for instance, well, Tanika's in Knoxville, maybe I'm down in Memphis. Well, maybe I'm even in Knoxville. Let's just say I'm in Knoxville too. And I haven't heard there's a Harper's Naturals out there. So I look up, it's not trademark. Well, I go get Harper's Naturals trademark because I'm trying to be proactive, right? So then could that then give me leverage? I mean, maybe legally, but like, how have you seen that kind of work?
Yeah, that's a good question. And it's a little bit technical, but for at least some period, so it's called priority. It's trademark priority. It's whoever comes first in time to use that mark is in a superior legal position. Okay, they have better rights. And so if Tanika was using Harper's Naturals first in Knoxville, but she didn't do anything, she didn't register, and then you come along and you register, you technically Tanika could take action against you for some period of time, and she could say, "Hey, Deidre, I came first. You're using my trademark. You're infringing. You got to stop." But after a number of years, the ability for Tanika to do that goes away. Okay, and so you kind of have to act fast, and you kind of have to keep an eye on your stuff, right? And so that, I guess the summary is yes, she could take action, but only for a small amount of time. So,
My question is for the trademark applications, because I know each application costs money. So when we're talking about, I'm gonna say, go with Coca-Cola. So do they have an application for the logo, then another application for the name, and then another application for the font? Or was this, they could do it all under one application?
No, it's 3 separate registrations. Let me see if I can
Hey,
Me.
Deidre.
Let me just see if I can show you. But yeah, they would exist separately as three separate registrations.
Mm.
Mm, 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 mm.
Because I'm thinking of what I need to do. Well, I wasn't even thinking about Shore Foundation, but now I'm thinking like, man, I do need to probably start getting that name and stuff trademarked. But then it's like, man,
I was just marketing. I was just marketing in case
I
you
know.
needed
I'm
it.
like, man, I'm about to send you an email when we hang up. But then I'm like, but dang, that's gonna be 6 applications.
Yeah. Yeah. So each way you register it is a separate registration, and it's actually, you know, on a good by good basis, technically. So you know, say Coca-Cola wants to register the same exact name, same exact, like without any without a logo, just the word Coca-Cola. They want to register it for t-shirts and soda. Those are actually, the way that I would do it would be 2 separate applications.
Wow.
Mhm.
But it's the same logo.
Yeah. And you pay separate, you will pay separate filing fees, because when you know you did it, when you file your application, you have a set of goods or services that you select, or you know,
Mhm.
and you specify, and they fall into classes, right? And so you have to pay a separate filing fee for each one of those classes.
Mhm.
I prefer to break out each application by
Separate.
class, so have a single class per application. It's just easier from a
Mm.
you know, management standpoint. You don't have to, but I do. But it is essentially, it's treated as entirely separate applications. So
Okay.
okay, so, and I don't know if this is an issue, but you know, a lot of times you'll have companies that will have multiple lines, multiple product lines, and then when they grow, they'll have multiple divisions or multiple, you know, companies underneath the parent company. And so a lot of times for those kinds of companies, it helps to have that top level company own all the trademark rights, and then license
Mm.
down to the subsidiaries. It's again just a management standpoint. It's easier to do it that way. So we've gone through that. Looks like we're at the end of nope, trademark registration process. Okay, so this is usually a question of how long is this going to take? How much does this cost? So each class of trademarks is $350 per class. Okay, so you want to do sodas and t-shirts, $700 filing fee. Okay. And then for me, at least, there would be an additional fee for my time to prepare the application on top of that. So, and then it's usually more efficient to file, like if you want to cover 5 different things and for your trademark, to file all 5 of them at the same time. And so that's going to reduce your legal costs, at least, for me at least. So this is a chart kind of showing at this point in time, like a snapshot right now, what I'm seeing of the amount of time that it's taking. It's a long process. And Tanika, you know, because yours has gotten held up.
Yeah, I mean, yeah.
So you know, you file your application and it basically just sits for some amount of time. And right, it used to be like 3 to 4 months, but COVID and who knows what else has, you know, significantly increased that time. So you have, you know, 10 to 12 months now before it's being processed. And then the trademark examiner, you know, they will assign an examiner to look at the case. They'll do the search. And what they're looking for is, has anybody else filed or has registered a mark that's similar to the one that you're wanting to register? And if there has been someone that's done that, then they're going to cause you issues. And that's the main issue that we're looking at, or that they're looking for. But there are other issues that can come up. And if they find an issue, they're going to issue an office action. You have 6 months to respond to that office action. And then say you finally are able to address all the problems that the examiner has raised, they're going to publish the application at the end of this process. They're going to say, yep, it's good to go. Now you have publication. So publication is a 30-day period following the examination process. And during that 30 days, third parties. So, that company down, Deidre, that you mentioned in Texas, that, they've been using the same name, and they're like, hey, Deidre's over in Knoxville trying to register my name, that kind of thing. And so they're going to say, hey, we got a problem. This, it got past the examiner, but it still doesn't need to be registered. So they could potentially do what's called an opposition. And that's it's kind of a little mini lawsuit, basically, at the trademark office, that it puts those two parties against each other. And ultimately, it's the decision is, can the mark be registered or can it not? And so it's like I said, a little mini lawsuit. Yeah.
I was just gonna say, before we move away from trademarks, because I know we're about to probably move into another, either copyrights or patents. If I hire Deidre, let's say, to do a logo for me, she's the creator of that logo. Does she technically own that mark or me?
That's copyright.
Oh, that's copyright. Okay, we ain't there yet. Okay.
Okay. The short answer to your question is it depends, of course. That's the typical lawyer answer. On whether Deidre is an employee, she's a graphic designer that's hired by Shora Foundation to do graphic designing work, then it's gonna be owned by Shora. But if she's just a freelancer, she owns it.
Okay.
And so what you end up having to do is you have to get an assignment or you have to get her to transfer her rights as the creator of that logo to you. And it has to be a written assignment. It can't be a handshake deal. It can't be a verbal thing. It has to be a written assignment. So, and it does tie in to trademarks because, do you want to be in a position where Deidre says, hey, I've got copyright in that and you're using it to brand your company, you're copyright infringing, you're infringing my copyright. You need to stop using your logo because I don't give you rights to it anymore.
Right. Yeah.
Wow. So I guess before we move to copyright, one question is, what would be a reason why I, as a graphic designer, so great question, Tanika, but what would be a reason for me as a graphic designer to either educate clients? Is trademarking something that I should be telling them about before we get to the copyright space?
Yeah, I think that it should be. All of these issues are something that you should be at least, maybe not educating, but at least saying, hey, this is an issue that you need to be educated on, that it's a concern for you. At the end of the day, it doesn't really matter for you, doing your graphic design work. It matters for them and whether or not they can use what you're selling them. So,
I guess my space is probably going to be more in this as a graphic designer, more in this copyright section that we're about to get into.
Yeah. Let's see.
While he's doing that, hey, Dominique, I didn't welcome. I didn't know if you wanted to take a moment to introduce yourself and what you do before we move on to patents. You are a little choppy.
Look, can y'all hear me now?
Yes, that is better. Well, it was. Well, oh, she's on mute. You're on mute now. Okay, we'll come back to Dominique. Okay. Sorry, go ahead.
Hey, Dominique, good to have you. Go ahead, Dominique.
Yeah, I think she's just having some technical.
Yeah, I'm sorry. Yeah, I am. Can y'all hear me now?
Yes.
Hi, I'm Dominique. I have a couple of businesses, but I have this wing / So I need info. I'm just trying to get information on that. But my company is Heaven Sent Soul Food. And so, what else was I supposed to be making?
No, that's it. That's good because you are still kind of going in and out. But Stephen, she's a food maker, so
Oh, okay.
her
Okay.
business is Heaven Sent Soul Food. So she may have some questions a little later related to maybe some recipes or something that maybe she's trying to protect. But
Okay, well, that's an easy one, and we may not get a whole lot into that, but the best way to protect the recipe is through keeping it secret and don't tell anybody about it.
but you know, you
And-
got employees, but I guess they will have to just sign a confidentiality agreement.
Okay.
Okay.
Right. Yeah, because I've had some people, I've had actually 2 family members. Family members that are working for me. So, but my main thing is wanting to get in, do I need it patent to, I'm trying to get it in stores.
Well, I was saying earlier, going back, trade secret, keep it secret, treat it as a secret, mark it as secret, and your recipe is what I'm talking about. Don't let anybody have
Okay.
access to it that doesn't need access to it. You might even, if it makes sense to, separate the recipe into 2 different halves and provide, you see this with KFC, for example, the was it 11 herbs and spices? They give one manufacturer 5 of the herbs and spices, and they give another manufacturer the other 6. And so nobody has the full recipe, and they get both of those bags of, partial mix and combine them together. And that's how you get the 11 herbs and spices without sharing the full recipe with anybody. But that's for recipes, that's the best way to do it. And you got to protect it. You got to keep it secret. Otherwise, you're going to lose your trade secret protection. But you were talking about, I think you were talking that
Gotcha.
you were wanting to be online. And that goes back to trademarks, the section that we were just talking about. Basically, the trademark will be the name of your company or the name of the spice or the name of your, service or whatever it is. We can register that to get you broader protection, but it's not necessary. You do have some protection just by selling that product or providing that service. We were talking earlier about Amazon, and if you want to sell on that platform, at least they're going to have you register your product or your service with the Federal Trademark Office. And so they're going to push you to that. And in a lot of ways, that's not a bad thing, because getting that protection, if you can, is a good thing. So that's where I would push you on that. In terms of a patent, I don't really see, for at least a recipe, I don't really see much value there. So helpful.
Yeah, that's good. And Dominique, we're getting ready to go into the patent section now.
Yep.
So you'll be able to see whether or not this
Okay.
applies to you. So yeah, we'll let him go through this process. And if we have questions, we just chime in.
So basically, a patent is
Okay.
it's a little bit different than a trademark. So patents, they cover inventions. So the latest greatest light bulb or whatever. And it's not just limited to a product. It could be a specific way of doing things, so a method. You could also patent a method. But it's different from a trademark, because a trademark you can keep for as long as you're using the trademark. You can protect that word, that symbol, for as long as you're using it. A patent is limited, and it's limited to 20 years from the date that you file the patent application. So that includes like the time that it's processing through the patent office examination of that application. That time is ticking, okay, and it's limited to 20 years. And so you get 20 years of protection. And so what is protection? Protection is you get to say, like, once you get the patent issued, you get to tell other people, you can't make my product, or you can't do my method, whatever it is that you've claimed in this patent. What it doesn't do is it doesn't say that you can do, like, if Tanika, you've invented the newest, greatest chair, it's got 4 legs, right? It's for some reason it's patentable. And you get a patent on the 4-legged chair. Well, you can keep other people from making that 4-legged chair, but it doesn't necessarily mean that you can make that 4-legged chair. Because what if I had previously patented a 3-legged chair? Okay. And so in order to make a 4-legged chair, you have to make at least a 3-legged chair, right? So you have to do what I've already patented. Okay. Yours is a little bit different because you added that 4th leg, but in order to get there though, you have to at least make my product. Okay. And so again, what a patent does not do is it does not say to Nika, you can make your 4-legged chair. You cannot make your product, because there might be somebody else that has patented a part of your process or a part of your product. Okay. And so the government, the US Patent Office, or where the other countries' patent offices, they will give you this protection, but they want something in exchange for that. They want knowledge. And so there is an obligation of the inventor to say, here's how you make this thing, here's how you do this process, or here's how you make this 4-legged chair. And so in exchange for that disclosure of all the details, how to make it, how to do it, whatever, we'll give you this limited amount of protection. So that's the motivation, or the public policy behind the patent system, is to grow the body of knowledge that we have. So that's kind of what this slide's talking about.
So that's interesting because, I don't even know if I should say this. This might get us down a rabbit hole, but I hope not. So when we are going through like our Black History Facts or sharing Black History Facts, it's a lot of enslaved people who got patents for like the ironing board or the hot comb or something like that, right? So I was thinking like, ooh, how was it so much easy? They ain't had no money. How is it so much easy for them to get patents? But now I see, because it's a contract between the inventor and the government. And so the government needed that patent, probably needed that how did you come up with the ironing board? How did you come up with the hot comb? Because they needed to know it to reproduce it. Now I could be stretching that a little bit, but I'm just thinking like, I didn't know it was a contract between the government and the inventor. I just thought the inventor comes up with a patent, and they go get it patent because they done invented this great thing. I didn't know the government necessarily had anything to do. I mean,
well, the contract is, you give us this knowledge, and in exchange, we will give you this piece of paper that gives you this right to go out and sue people that's doing whatever you've protected, whatever.
But it's a win-win. Yeah.
Yeah, that's the idea.
So then two things. One is, it probably was easier too, Tanika, because there was nothing else like it before, right? Because I hear, Stephen saying that you got to do something before you can get the next patent. So then I'm thinking, so then my question is, well, if there's a spoon, I don't know, spoon scoop, ice cream scooper already invented, then can I get access to that current patent to see what it is? And then maybe I can just do something a little bit different to get a different patent. Is that like public knowledge, I guess, patent?
Yeah, so after the 20-year term, it enters the public domain, and it's available. I mean,
okay.
And all these patents are available. Like a patent application is public knowledge, unless the person filing the patent application has requested that it not be. But in most cases, patent applications are published. But yeah, once that 20 years is up, you can use the knowledge, and that's what it's for. Like you're supposed to, right?
Okay.
Now, whether or not you could get a patent on the latest greatest spoon, that's what part of my job is, to convince the patent office that, yeah, whatever Deidre has changed, it's a longer spoon, and it's got, whatever, whatever feature we've added, it's the latest greatest thing, and it warrants that another 20 years of protection. Okay.
Gotcha.
And so the patent office, a lot of times they're like, no, that's obvious. That change, that's obvious. And so we're not going to give you 20 years of protection. And so that's part of my job, is to convince them that it is more than just an obvious change, and that
Okay.
they should give us a patent.
Okay, good stuff.
Okay, so patents are territorial, which means a US patent covers you only in the US. There are no international patents at all. It does not exist. There's no, what do they call it? Poor man patent, where you like write down your invention and you put it in an envelope and you mail it to yourself. That doesn't exist. I get that one a lot. But going back to the territorial thing, if you want to protect your invention in Canada, like you got to file a Canadian patent. Or if you want to go over to France, you got to file a French patent application. So you get to file on a country by country basis. And so, like I was saying, what it actually does is it here at the bottom, it keeps other people. It allows you to keep other people from making, using, selling, or importing that four-legged stool into the U.S. or in the U.S. So if you only have a patent here in the U.S., Tanika's your four-legged chair is only protected here in the U.S. That doesn't cover you in China. And so what that means is you can have somebody in China go and make this same four-legged stool, right? Because your patent rights don't extend to China, okay? And usually that's not a problem because the biggest market's going to be here in the U.S., right? And so if your customers are all here in the U.S., you don't really care what's happening in China. But if you are selling abroad, then it is a concern. But it's very expensive to go outside of the U.S. So unless it just is justified from a cost perspective, it usually doesn't make a lot of sense. So this is an interesting slide. There are three different types of patents in the U.S. The first one, I'm going to jump down to the third one, the utility, and that's what you normally think of when you think of a patent, and it's going to protect that device, that four-legged stool, or a new method, a new way of doing things, the way of making that four-legged stool, for example, or a new chemical, a new pharmaceutical drug, that kind of thing. The first one is the second most common, and it's called a design patent, and it protects the way that something looks versus the way that it works or goes together. And you see that a lot in like furniture and shoes and like that kind of thing. Like there was a big case in where Apple sued Samsung, or Samsung might have sued Apple a few years back on the way that the phones look. And it's interesting, prior to the invention of the iPhone. Oh, that's what it was. So Apple sued Samsung because Samsung basically aped the shape and the design of the iPhone. But before the iPhone came out, like Samsung phones look completely different. And so anyways, there was a design patent on that iPhone, and Apple, if I recall correctly, made a ton of money by suing Samsung because Samsung made a ton of money by selling this basically copied iPhone. So that's kind of where those types of patents are useful. And then plant patent, I've never seen one, and I always talk about it, but it's basically just a way to protect a specific type of plant. And like I said, I don't know a whole lot about that, and I've never seen one, so I'm not going to talk about it. Okay, so this is interesting. Payment of maintenance fees. So once you get a patent issued, you don't automatically get that full 20 years. The government wants its money. And so about every 4 years after you get your patent, you have to pay more money. And that's called a maintenance fee. In other countries, and it's not inexpensive. For big companies, I think it's like $8,000 for that third one. It is not inexpensive. In other countries, those maintenance fees are paid annually versus every 4 years. They're smaller, but they're paid every year. And the idea there is kind of the same idea of if you stop using your trademark, then your trademark rights go away. Okay. And that would allow somebody else to start using B&B, right? If for lawn care, like you guys go out of business, like we're not going to keep protecting that because other people
Mhm.
might want to use that, right? And so your trademark rights will go away. Same for patents. Like if you're not paying for it, you don't see value in this patent, you're not going to pay these maintenance fees. And so then we're just going to let this patent expire. We're going to let that information go into the public domain, and maybe somebody else can use it.
Wow.
Okay.
So another example, I guess, of a utility patent would be, so if I am a hairdresser and I came up with a really great process of, it's different than what's already out there, of how to do locks, how to lock somebody hair up. It's a process, it grows them faster, longer. I don't know, but it's a process that I invented, that I came up with, and I want to protect that.
Yep.
Would that be like a utility patent?
Yep.
Okay.
Yep.
So then, because then you can take it a step further, because I've seen where it's a tool that somebody has created to make the lock. So it's like you need to get the tool patent and the process patent. Would that be right?
What?
And a lot of times a single patent will protect both the device and the method of using that device. You can kind of protect related things in a single patent sometimes. So
Or if Dominique has a process of how to, that probably won't work, like how to make a roast beef, like a certain, like if it was like a secret recipe and it was like the way she did it, like she might put it in the oven 4 hours, put it on the grill 2 hours, and then put it in the crock pot 3 hours to get her special kind of roast.
yeah, it's possible. It's certainly a method. I'm not sure that
That would count.
methods of cooking. Yeah.
Okay.
I still think that that's going to be better held as a trade secret.
Trade secret. Okay.
Yeah.
I'm just trying to wrap my head around utility patents. That's all.
Yeah. Utility. So it's products, the way that a product goes together, the pieces that make up that product, or a sequence of steps, a method or a process, something that is made through following a sequence of steps, pharmaceuticals, that kind of thing.
Okay.
Yeah. So I guess one last difference, or a couple of differences between design patents, which again covers the way that something looks, and the utility patents, which is the way that it's made or used or whatever. Design patent only has a 15-year term versus a 20-year for utility, and there's no maintenance fees for design, whereas there's 3 maintenance fees for utility. Okay, patent pending. You are patent pending as soon as you file a patent application. And so there are a couple of different types of patent applications. The one you normally think of when you file it and it gets examined and it could potentially lead to a patent being granted one day, that's called a non-provisional patent application. And again, that's the one that will eventually be examined. There is, and I guess to understand, there is a provisional. And so a provisional is not examined, it does not lead to a patent. And the reason that you would file that is it serves as a filing that will give you the ability to market your product as patent pending. But it also basically serves as a placeholder, puts you in line for potentially to get a patent. And so to understand that, in the US and in many other countries, the first inventor to file their patent application is the one that gets the patent, or should get a patent. And so if you file that provisional first, that a lot of times there's a race to the patent office, and you file that provisional first, and that holds your place in line. So, Deidre might file a provisional on her 4-legged stool just a week before Tanika does. And, that's going to give Deidre the ability to get the patent before Tanika, or over Tanika. The key is that the provisional expires after 12 months. Okay, so if what you have to do is you basically convert that provisional into a regular non-provisional before that 12 months expiration date. So, Deidre files the provisional, but she waits 13 months. Now Tanika is first in line. And so now Tanika gets the patent.
Mhm.
Make sense?
Mhm.
Okay. Moving on. So one of the important rules about inventions is there is a time limit on when those have to be filed. And so, we were talking a little bit earlier about timing. For inventions, you want to file a patent application before you've talked about the invention publicly at all. But if you do, in the US at least, you have up to a year from that date to file a patent application. And if you wait a year and a day, you are too late. Okay, and you do not get an invention, or you do not get a patent on that invention.
Really?
Yep.
It's like, that's interesting because I might want to talk to somebody about my invention to see that it's cool and that, like, just to see that, like, yeah, that's a thing. Yeah, that's dope. So it's interesting that, like, and then they only give you a year.
Well, and that's part of why the provisional makes sense, is that counts as your filing. So you file your provisional, and then you're like, hey, Deidre, let me talk to you about this new thing, that I filed a provisional on, and so that's how that works. That's how those two go together.
Yeah. Okay.
But yeah, you have a year from any public disclosure. So a sale or a presentation or a pitch, anything like that where you're talking about your product, you have a year from that date. But that's only in the US. In certain other countries as well. But a lot of countries, they have what's called the absolute novelty requirement, which means before you tell anybody, you have to file. There is no grace period. There is no 1 year. You have to file. And if you don't, and you try to get a patent, and that patent is going to be invalid in that country.
Wow.
So, very important. I'm not going to go through this. So to get a patent, there are a couple of requirements. One, it has to be new. So that's the novelty requirement. You can't refile a patent application on, the Model T, right? Has to be something new. Has to be useful. Like there are certain categories of things that the patent office says are not useful. One of those is a perpetual motion machine, because it does not work. If you've ever studied, science, perpetual motion can't exist. It like breaks the laws of thermodynamics. And so the patent office says you can't patent that. There's no use to it. And there are other categories too, but that's one of them. And so then this is getting back to what we were talking about earlier with the spoon idea, is a longer handled spoon, is it more than obvious? So the difference between what was done in the past and what you're trying to do has to be more than obvious. And so that, getting back to Deidre, what we were talking about earlier, that's part of my job, is to convince the patent office that, this innovation, what makes us different from what came before, that is more than obvious. And there's no bright line on that. It's all legal argument. Any more questions on patent? Anything else there? Copyright will go a little quicker. Okay, so copyright is for creative works a lot of times. So photos and, basically everything you do, Deidre. Musical works, choreography, which my wife does, anything like that. And you get rights automatically as soon as it's fixed in a tangible medium of expression. So as soon as you write it down, or as soon as you draw it, or as soon as you take the photo, like you get copyright automatically without doing anything else. And you can choose to register if you want. and I think we'll get into this a little bit later. Hang on, let's see.
Work for hire.
Go back to trademarks. You can choose to register your copyright, and there are certain legal reasons to do it. One of those things is, one of the advantages is, or one of the reasons why is, if you want to sue somebody for basically ripping off your say your artwork, Deidre, if you want to sue somebody, you have to have registered with the Copyright Office to even take it into court in the first place. And then once you get to the courthouse and you're trying to get money, if you have not, if you have not registered before the infringement happens, right? So you waited and you're like, man, they took my whatever, my logo or whatever. And then you go out and register, and then you sue them. Then you have to prove, well, how much actual damages their copying cost you. And so that can be very difficult. Like, I don't know, like $10, who knows? Like, you have to go and figure out their numbers and figure out what kind of money damages it actually cost you. Versus if you had registered prior to them stealing your work, your logo, the law itself says $750 up to, I think it's $150,000. It's called statutory damages. It says you can choose that, or you can choose what actual damages that you can prove. Okay. And that's a whole lot easier to say, I'll take what the statute says, than having to go out and show, how much they've, I mean, there are exceptions, like obviously, like you rip off a Marvin Gaye song and that you may have remembered the Robin Thicke Marvin Gaye dispute a few years ago. Millions and millions of dollars in potential damages. And so that's a case where you were like, I'm going to go with actual damages in this case, right? Versus the statutory damages. But in a lot of cases, though, the statutory damages is a big advantage, right? Because you don't have to show anything.
So then, I guess, should I want to keep all the, well, I guess the question is, if I do a logo for Tanika, so should Tanika want to just on her own say, well, let me copyright this, or would I have to copyright that because I made it, and then like transfer through documentation the rights over to her?
Yeah, and I guess that kind of gets to what this slide is talking about. And we talked about it a little bit earlier. The general rule is the artist, the person that creates the work, they're the ones that own the copyright. There are a couple of exceptions to that. One is what we were talking about, the work for hire, where Deidre, you work for this company and you are doing it within the scope of your employment. You are hired by Tanika to be a graphic designer. Like in that case, then Tanika or Shore Foundation, they're going to own what you create without any kind of transfer of rights. Otherwise, you have to assign those rights to whoever needs to own them. So your clients, for example.
Okay.
Whether or not it makes sense to do that, it's up to you. If I am representing the person that has hired you, I'm going to say, absolutely, you better get an assignment from Deidre. If I'm representing Tanika and you've designed a logo for Shora Foundation, right? I'm going to say, Tanika, you better talk to Deidre and get an assignment, because we don't want Deidre to, 5 years from now, get crossways with us and say, stop using my logo that I designed, right? And I think that it's probably good business for you to give them those rights, unless there's some reason not to.
Okay.
I think it's going to be easier, long run, but I don't see any reason for you to hold on to them. So.
Okay. Now, is there like a official document, or can it just be like a typed up document? Hey, I'm assigning the rights. We signed it. That's enough.
Do you have a written contract for your clients?
I don't. That's the next workshop I'm going to attend.
Well, I would suggest that you do. I
Okay.
suggest that you have a contract that kind of sets out, your fee and the expectations and the warranties if you should not warrant. But any terms that you are going to operate under, it would set it out there. And it can be a very simple, short thing that you can use from one client to the next, but you should have that.
Okay.
And it would be in that agreement that you would assign your rights over to the client, provided that they meet all, they've paid you on time and blah, blah, blah. And there are some things that you probably would want to include in that. For example, a license to use it or to feature it in your portfolio, for example, right? That kind of thing.
Okay.
And so there are standard agreements like that you can probably easily find online. But that's where that would normally happen.
Okay. That
And
was helpful.
yeah, so Booth will be with us next month, Deidre. So that's what part of what she does. So that might be a good question for her. I mean, a good thing to bring up next month. But it would be interesting if somebody didn't have that like written agreement, that assignment, and like y'all fell out over something petty, and then they come back and be like, well, you can't use the logo I created no more. If you didn't have that agreement, like I'm sure that has happened in place and time, but this is great information because I didn't know that, because we have a lot of people who are a part of the Roots Collective who are either graphic designers or they are looking for a graphic designer. So one or the other. We have a lot of entrepreneurs on both sides of the aisle. So this is just good information to know, because if I'm hiring somebody to do a logo for me, whether or not they have that contract, I need to be asking them for that assignment. Like that's something that now I need to be knowledgeable in, to even say, well, hey, I'm hiring you as a contractor to do some logos for me or whatever that is, but I need an assignment saying that after that it belongs to me.
Yeah, and I mean, they don't necessarily have to assign, like an assignment is where they transfer all of their rights over to you. They could also give you a license if they didn't want to do that.
Okay.
So a license, they give you some of the rights, but not all of them. And that would protect you too.
Okay.
So that's another option. And, would they ultimately be able to keep you from using the logo after you had hired them to design it for you? Maybe. But there certainly would be an argument that there's some sort of equitable, fairness argument that they could make, or that you could make, that said, hey, I paid for this logo to be designed, and now they're coming to try to like claw it back, right? But getting the assignment or getting that license is just going to shortcut that argument altogether. Like that's part of my job, is to keep issues from becoming issues. And so that's one of the things that we can kind of just remove that as an issue from the beginning. So.
I think it definitely helps there, but then it would also prevent Deidre from doing a very similar like logo for somebody else. Because if she owns it and she doesn't like assign it to me or let me license it, she could potentially create something. She wouldn't probably do the exact same thing, but she could potentially create something very similar in nature for someone else, right?
Yeah.
Yeah. So
that'd be one of the issues that you would want to talk about in your agreement, right? I don't know exactly how we would handle that, but it's something worth putting some thought into.
Yeah.
So it is, Deidre, I would strongly suggest you have an agreement, because a lot of issues will be avoided if you have something written in paper. People that want to start stuff with you, they're going to not start stuff with you because you have something written. Okay.
Okay.
Let's see. So I told you copyright's going to go fast. I guess another advantage to the registration process is, in addition to those statutory damages that I told you about, you can also potentially, if you have to go sue somebody, you can get your attorney's fees paid as well. Which again can be a huge deal, right? When you're talking, somebody that charges multiple hundreds of dollars per hour and hundreds of thousands of dollars per case. So it can make a loser case a winner case.
Real
Right.
quick.
Very quick. And so for, I guess, to kind of give you an idea of cost, and I'll go back on costs for the patents too, but for a copyright application, I believe the filing fee is $55. And it takes usually less than 6 months to get it filed. It's a very simple process. It's basically just an application that, you list your name, you list the title of the work, when it was created, that kind of thing. And then on the Copyright Office website, you upload what's called a deposit copy, which is a PDF or of your artwork. You would upload that to the patent or to the Copyright Office. Or if it's a song, you might upload a WAV file of that. And so then that's really basically it. So very well worth the $55 if it could potentially avoid somebody infringing, or if somebody does infringe, gives you the ability to go after them.
Mhm.
Stepping back on the patent side, the filing fees on that are $400 to $800, depending on the type of company that's filing the patent. Smaller companies pay less fees than bigger companies. The real cost comes in because a patent is usually like, we're talking a utility patent, so the ones that cover the how it's made and goes together and the method. It's usually 15, 20 written pages that a patent attorney like myself would put together. And so you're talking significant amount of time and billable fees. And so you're usually in the $8,000 to $15,000 range just to draft the patent application itself.
Mhm.
And then you have to go through the examination process. And so I usually tell my clients, budget on another $15,000 for that at least.
It's expensive.
Yeah, Lord Jesus, that no wonder people are out here trying to finagle their way through it. That's woo.
Yeah.
Yeah.
That's not something I need.
Yeah. Yeah.
I do not need that. No.
Like, what'd you say about trade secrets? That's a great idea.
Yeah.
Great idea.
Let's go back
to the route I need to go.
Yeah, be like, let's go back to that.
Next slide, please.
Yeah.
Right.
Don't even include that in the slide.
Yeah, that's okay. We don't need that information.
So I guess trade secret was next.
Yes.
Okay. So Dominique, so recipes, again, trade secret's probably the best way to protect those. It has to be information that is valuable, and you have to take steps to keep it secret. So a lot of times it's you've limited access to that information. You don't just have the recipe card sitting out on the countertop, right? You have access controls, so password protected. Need to know only, like unless you're if you're the fry cook, you don't have to know the 11 herbs and spices for the chicken, that kind of thing.
Right.
I guess another consideration is if somebody figures it out independently of you, you figured out the 11 herbs and spices, but you didn't get it from Kentucky Fried Chicken. Like you figured, like you were in the lab and you're in the chicken lab and you figured it out, you lose, or Kentucky Fried Chicken loses its trade secret protection at that point. Okay, because it's no longer a secret.
Right.
Okay, so here's some interesting trade secrets. Coca-Cola formula, algorithm for Google, Twinkies. So we're getting to the end. Okay, so here's some famous trademarks.
So, okay, yeah. Oh, no, the next slide. I think that's where I was going to have a question. Yes. So protecting the trade secrets, I guess, like, confidentiality agreements with any employees or anybody that needs to have access to the secret needs to sign a confidentiality agreement. And if then they go make the fried chicken batter with the same secret, then that gives her leverage to take them to court.
Yep.
Okay.
Well, it would give her evidence that they knew that it was a trade secret and they decided to use it and to misappropriate it, which can be useful. And it can also give her a breach of contract claim as well. Okay. So if she's using the 11 herbs and spices after she told them, you cannot use it after you leave my employment, that's a breach of contract. So it just is establishing multiple causes of action that she could assert.
So can she still, now I'm asking for me because I have my employees sign confidentiality agreements. So let's say we have the confidentiality agreement, but I have not registered anything. I haven't registered a trade secret, but they've signed a confidentiality agreement. Is that null and void, or do I need to have that trade secret registered and have the confidentiality agreement?
Trade secrets are not registered.
Oh, even better. Okay.
Gotcha.
You don't do anything. All you have to do for trade secret, unlike copyright and patent and trademark, all you have to do for trade secret is just keep it secret.
Okay. And
That's
do
it.
these things, confidentiality agreement, hiring procedures. Okay, that is so good to know.
So Dominique is a whole lot cheaper than a patent. So,
It sure, it
Like,
sure is.
let me Google this confidentiality agreement.
there you go.
Right. I'm about to write up one right now.
Yeah. Okay, so that's pretty. And I didn't realize some of the other things on that list, which that's why I have my employees do confidentiality agreements, but like customer lists, pricing information, like I didn't realize that those are trades, that those could be considered trade secrets. I think when I think of trade secrets, I only ever thought of like recipes for food, recipes for some type of product. But
Yeah,
I didn't,
it's anything that, like I said, has any information that has value
that's
to your business.
proprietary. Yeah.
Yeah, it's stuff that, I spent this much time going through figuring out this whatever,
Mhm.
and somebody else, they'd have to go through that same process to figure it out. That's valuable, right?
Yep, that is valuable.
Right.
And so for like Harper's Naturals, we have to, because it's a product, we actually have to list, well, and I guess grocery stores do too, have to list our ingredients on the packaging, because you just have to do that. So I guess the secret is how much of the stuff we put in it, because we don't have to list the formula, right? We just have to list the ingredients.
Right.
Okay. That makes sense.
Yeah, so, marketing methods, how you're reaching customers, that's valuable. How you're any kind of information that you have value, that you associate value with, can be trade secret.
Can be a trade secret. And I didn't ask this because before we started, I know that I said I was gonna have a question about this, but so it might be under copyright. So our entrepreneurial curriculum that we're building from scratch in-house, once we get that curriculum developed and start selling it, that's copyright. But do I need to get the copyright before I sell it? Okay.
Yeah, it's easier to register a copyright protected work before it's published. So before you publicly disseminate it. So, so it's kind of like patent. So patent, you want to file before anybody knows about it, right? Because we had that public disclosure rule. Copyright, we want to file it before anybody knows about it.
Okay.
Trademark, before you can get, it's different. Trademark is different because before you can get a trademark registered, you have to already be selling that product or providing that service using that name.
Okay.
And so it's the reverse. You want to actually be using that trademark and then file. Okay.
Okay.
You can do it the other way around. Like you can file before you've done it, but it's more expensive. Okay. Because in that case, you file and you don't show use when you file, and then you go through the examination process, and then you start using, and then you have to submit that proof of use. And so it becomes a multiple step process. And of course, the trademark office, they're charging you at each one of those, steps.
Okay.
So it's a lot more straightforward, and it's a lot less expensive to just start using the trademark before you file.
Okay. Not the copyright before. Okay. Did y'all have any other questions? I don't know. I'm assuming, are we at the end of the slides?
We
Steve?
are, yeah,
Okay.
yeah.
Deidre or Dominique, did y'all have any other questions for Steven while we have it? This was so helpful.
Good.
Thank you
It
for
was.
your time and doing this. And that's why I always say what we don't know, we don't know. And there was a lot of this information I did not know. And I'm better for it
Right.
now for knowing it. So I don't have any more questions, I don't think, but thank you. But I'm gonna let Deidre and Dominique see if they have any more.
Okay. Well,
I don't think.
for Dominique's benefit, I'm going to go back to the first slide. It's got my contact information.
Yes.
In case
Okay.
you need
Thank you.
me. That's my direct dial. That's my direct email. You can reach me there. Let me move this. So you can reach me there. But yeah, I'm happy to
Appreciate
do it. It's always a lot of fun to do and a lot of interesting questions. And yeah, wish you all the best of luck. So.
Thank you,
Thank you so much.
so much. And I'll make sure to, if we get any questions, which I typically don't get questions about trademarks and stuff because people are just not thinking about it. But
Yeah.
I will definitely keep your information and refer people to you as I need to. So thank you.
All right. You guys have a great night.
All right, you too. Thank you.
See ya.
Bye-bye.